Welcome to episode number 197 from AAA Weekly Webinar Series. We have deliberated on various Supreme Court judgments, landmark Supreme Court judgments in our last episode, number 196. Today we have curated certain judgments from NCLAT, the Appellate Tribunal, and some landmark judgments which we could find, and that is what we are deliberating today, which is delivered during 2025. As we said, 2025 has actually been a so-so for insolvency, but 2026 is going to be much better. Number one, the Insolvency and Bankruptcy Amendment Bill 2025, may it get passed in this budget session, and finally it will get the accent of the President. So then the regulations will come and there will be a lot of material to give you the information and different episodes. Then also the NCLT capacity is also going to be increased, so that way the 2026 is going to be much better than 2025. During 2025 also we have done a couple of episodes where some of the NCLAT judgments were in fact presented before you through our analysis. Like what we had done in our episode number 157, we deliberated on judgments between January 25 to April 25, although there are some judgments which were not included in that episode that we have brought in today, and maybe it was passed during the same period, which is basically January 2025. Then we also have posted some of the NCLAT judgments in the Courtroom Voices series. That is the 9th number of this series that was posted on 17th of July 2024 on the YouTube portal as AAA Insolvency. The certain basically what we are bringing to you is one. I think let us start with the judgment number 1 today, which is the Employees Provident Fund versus Jaykumar Pasumal Arlani, the resolution professional of Decent Laminates Private Limited. This judgment was given by the Chairman's Court at Principal Bench, New Delhi on 3rd of January 2025. So this judgment was important, so therefore we thought of deliberating on this judgment in this episode. Now this judgment in fact has done a very critical and very meaningful differentiation between moratorium under section 14 subsection 1 and the moratorium under section 35 during liquidation process. Now in this case, the facts of this case is there are two separate appeals were in fact decided by one order, and one is the Decent Laminates Private Limited CIRP started, and while the CIRP was ongoing, the Employees Provident Fund Organization EPFO initiated proceedings under section 7 capital A of the EPF and MP Act on 9th of May 2023. The summons were issued regarding damages and interest under section 14B and 7Q. Now, I would be actually saying that the CIRP started in May 21, and these kind of summons in fact were issued in May 23. May 23 and May 21, that's exactly 2 years. In this case, the EPFO, Employees Provident Fund Organization, submitted a claim which was about 676 lakhs. That was in May 2023 after passing the assessment order in August 23. Now, the May 23 summons, in fact, again resulted into additional demand, and then the demand in fact was added. Instead of 76 lakhs, they in fact submitted a revised claim of 1.59 crores. Now, the basic issue in this case was the RP refused to consider that claim which was filed in September 23 because the resolution plans had by that time been approved by the COC NCLT subsequently rejected the EPFO application, noting that the claim was submitted at belated stage. Now, in the second case, since this was a appeal where one common order was passed by NCLAT and these two appeals separately, in another case like this was the CIRP commenced in July 21 and the inquiry in fact started much before CIRP, that is in 2019. The inquiry and section A 7A proceedings started much before CIRP started, but the final assessment order was passed, and that was passed in August 22, that is during CIRP. RP informed the EPFO that the COC had already approved a resolution plan, therefore RP was prohibited from accepting the claim. NCLT rejected EPFO's application, ruling that the assessment order was hit by Section 14 moratorium and no claim had been lodged prior to the COC approval of the plan. Now, before appellate tribunal, the question of laws which was framed was whether after imposition of moratorium under Section 14 of the IBC, assessment proceedings can be carried on by EPFO under Section 7, capital A, 14B, 7Q of the EPF and MP Act 1952. Second question of law was whether any claim on basis of assessment subsequent to imposition of moratorium can be admitted in CIRP. The third question of law was whether claims which were filed by the appellant subsequent to the approval of the resolution plan by COC could have been admitted in the CIRP. So why this case is very important? Because in most of the cases during liquidation or during CIRP, EPFO is filing claims. EPFO is actually starting the proceedings. Summons are coming to the RPs and the liquidators. And this particular case, the ratio which is decided in this case is also applicable on various service tax, various the GST, income tax, because in the assessment process, in fact, the NCLT has very clearly defined what is the proceedings, what is the difference between CIRP and what is the difference between liquidation. So I'm actually bringing all those, the portion of the appellate tribunal. Now, in fact, the appellate tribunal, NCLAT, dismissed both the appeals by EPFO, affirming that Provident Fund assessment proceedings cannot continue. Assessment proceedings cannot continue during once a moratorium under Section 14 of the IBC is in place. NCLT, in fact, focused on three aspects of moratorium. So this judgment, in fact, would be applicable to various assessment proceedings. One, NCLT held that while Section 33 subsection 5, that is during liquidation, and the Older Companies Act, that is Section 446, use the specific term legal proceedings. So Section 33 subsection 5 of the liquidation and earlier Companies Act use this section, use the specific term legal proceedings. Section 14 subsection 1 of the IBC uses the broader unqualified term, that is proceedings. So legal proceedings and proceedings. Section 14 is using the word proceedings, whereas Section 33 subsection 5 is using the word legal proceedings. So therefore, tribunal observed proceeding is not qualified so as to confine it to proceedings before the civil court. The proceedings which have the effect on the asset of the corporate debtor are all covered in the expression proceedings. So if there is a summon, if there is an assessment proceeding, if there will be any notice, if there will be any demand, that is impacting the assets of the corporate debtor. So that is included in the word proceedings, but not in the word legal proceedings. The tribunal further clarified that any proceedings that has the effect of depleting the assets of the corporate debtor or creating new liabilities. Depleting the assets of the corporate debtor or creating new liabilities must be frozen to allow the resolution process to proceed unhindered. Consequently, EPFO was prohibited from concluding assessments under Section 7A, 14B and 7Q of EPF Act during the CIRP. Then the question was validity of claim based on post-moratorium assessments. On this particular aspect, the appellate tribunal ruled that if an assessment was carried out in violation of Section 14 moratorium, any resulting claim cannot be admitted into the CIRP. The tribunal stated no claim on the basis of assessment carried during the moratorium period, which is prohibited under Section 14 subsection 1, can be pressed in the CIRP. Now, another issue, claims submitted after resolution plan approval. Now, on this issue, the appellate tribunal held and emphasized that the IBC is a time-bound process. Because the EPFO submitted its revised claim after COC had already approved the resolution plan, the RP was correct to reject them. The tribunal cited Supreme Court's ruling in RPS Infrastructure Limited versus Mukul Kumar, noting that the claims filed at such a belated stage cannot be admitted. The correct observations of the appellate tribunal was in fact a very article distinction between CIRP phase and the liquidation phase. During CIRP, Section 14, assessment proceedings cannot continue because they might create new liabilities that hinder the shield intended to protect the corporate debtor. So, assessment proceedings can be of various types and kinds. Assessment proceeding under income tax, under service tax, under GST, or maybe for TDS. So any kind of assessment proceedings, any kind of civil inquiry which actually will raise some tax demand or any other demand. So all this is considered to be under moratorium. So during liquidation, Section 33, subsection 5, the appellate tribunal noted that the bar is only against suit or other legal proceedings. Therefore, after the liquidation, it is open for EPFO to carry on the assessment. So this is something which is, in fact, a very important judgment. All professionals, they are presently facing difficulties regarding all these notices, summons, assessment proceedings, which are actually getting started. Yes, during liquidation, it can still be started but then during liquidation, there is one further hindrance, that the liquidator has no power to admit a claim which is filed at a belated stage. So therefore, even during liquidation, if there is any assessment which is completed and there is any claim which is submitted to liquidator, the liquidator is bound to reject that. And then the organization, may it be EPFO, may it be Income Tax Department, or may it be a GST department, will go to the adjudicating authority and may or may not get a relief. So that's what the importance of this judgment is.
So a question here, that in case the insolvency professional has already admitted the claim based on prior experience and prior jurisprudence that was available prior to this NCLAT judgment, and today there is an admitted claim from EPFO which is based on an investigation or an inspection done post CRP initiation. So can today that RP can use this judgment and say that this claim is effectively now removed from the claim register based on this judgment?
No, once a claim is admitted by the resolution professional and that is admitted before the resolution plan is approved by the COC, that claim is valid. It is not possible to now go back and say, no, because of this judgment, I can the RP has no option that after admitting a claim, he can change it because there is a judgment now. I had originally admitted it incorrectly. No, that was not incorrect admittance, because in case the RP has admitted and it has been factored in the resolution plan, so that actually will continue.
But where resolution plan is not available and is still at plan stage, it is still at the stage where fresh claims can come, resolution plan is not yet final, and yes, the RP had admitted a claim because he understood at that point in time that it can be admitted.
No, once the RP has admitted the claim,
so then there is no change.
I don't think there is any change which actually the RP can done. I think what your question is that the summons or the notices or the inquiry continued during CIRP. Assessment order was finalized during CIRP, and the claim was also submitted by the EPF or any such department during CIRP, and the same was also accepted by the RP. Yeah. Now, once all this has been done, now the RP cannot go back, because still the resolution plans has to be prepared and it can be factored in.
So can RP in that case file an application in NCLT seeking permission to remove that claim from the claim register based on this judgment?
No, because let us understand the basic objective of this judgment from the appellate tribunal. The judgment very clearly says that once the resolution process is over, it is already the resolution plans are already approved, then we can't go back, we can't disturb the entire process. But if it is already in process, I think the NCLT will do justice with more and more claimants. Right. That is the logic, because in this judgment, both the appeals, one thing that we have noticed, that when the claim was submitted to RP, by that time the COC had already approved the resolution plan. So therefore, the adjudicating authority was also kind of bound by the resolution plan, which has already been approved by the COC. So it cannot be sent back, that you now add the EPF or any other claim and then again come back. That's not something which is desired. However, in case resolution plan is not approved and still the claims have come, that of course nowadays even the regulations are very clear that any claim which even comes 7 days prior to that meeting in which the resolution plan is approved, then it becomes the duty of the RP to approve or reject that claim and also present it in the COC meeting and also get it factored into the resolution plan. So it is not possible to withdraw once it is admitted before the resolution plan is approved.
The next judgment that we have before us is again an NCLAT judgment from the principal bench, and this is Amit Dinesh Chandra Patel versus State Bank of India and another. This was decided on 3rd of January 2025, and it takes care of a very peculiar matter. It kind of takes it is filed by Amit Dinesh Chandra Patel and also Rahul Arun Prasad Patel, both the applicants, and the CD, the corporate debtor in this matter, is Shirpur Power Private Limited. And the matter here was that SBI, Bank of Baroda and IDBI Bank had entered into a common loan agreement, which is also called CORLA. And this CORLA is where they had appointed SBI CAPS as the trustee to secure the to secure as a security trustee for holding or dealing with security, including guarantees for benefit of COR lenders. So what happened here was that this personal guarantee agreement was also signed with the appellants, and what happened is that the personal guarantors went to NCLAT and said that SBI has filed this case, whereas our guarantee agreement is with SBI CAPS. This was one argument that they made before NCLAT. The second argument that they made before NCLAT was that what is the authorization based on which this SBI person who is filing this NCLT application is authorized to represent SBI. Both these matters and both these issues were extensively discussed in this judgment. Rather, portions of the CORLA were also are also forming part of the NCLT order and also form part of discussion in the NCLAT judgment, where it is said that the CORLA specifically allows any of the lenders who are participating in that loan agreement to initiate any proceedings against the corporate debtor or the personal guarantors, and that is what was referred to by the NCLT in their order when they passed this personal insolvency order. The NCLAT accepted the NCLT's judgment on this and said that no interference is required. The NCLT's order to initiate insolvency was perfectly good. So section 7 application here, which was filed against the CD, was understood to be perfectly right. And also earlier, and then section 95 application was also something that was upheld by NCLAT. The second issue that was discussed or that was talked about in NCLAT judgment is how the SBI officers are having the jurisdiction to appear in the NCLT or file this application before the NCLT. So what NCLT referred to here and NCLAT also referred to here was a notification dated 2nd of May 1987 under Regulation 76 of SBI General Regulations, which allows any officer in grade SMGS 4 and above to authorize to exercise signing power in respect of documents connected with the bank's business. So that notification was brought to the attention of the NCLT and the NCLAT, and NCLAT said that even the authorization is in place based on that notification. Therefore, the entire matter was, the NCLT order was upheld. It was the appeal was dismissed.
See, while I discussed the RP's obligation to admit a claim or reject a claim, and that was something which was EPFO or similar kind of claims from statutory authorities where the assessment proceedings are completed during CIRP. Now, in the next judgment, which is the CSA Corporation Private Limited versus Rajiv Bhatnagar, the resolution professional, this judgment was also delivered on 3rd of January 25. And in this judgment, it's a unique case of claim which was rejected by the resolution professional, and finally the appellate tribunal held that the resolution professional was perfectly all right by rejecting such kind of claims. Now, in this appeal, the CSA Corporation, the appellant filed against the RP, and basically the corporate debtor in this case is Green Lighting Private Limited, and there was a consortium agreement between the appellant, means the appellant in this case is CSA, the consortium agreement with the corporate debtor, and then again a joint venture agreement that was in 2017, and it was basically to get 4 street lighting projects which was not completed. Then the appellant in fact issued notices for non-performance to the corporate debtor in 2021. Corporate debtor had earlier sought its outstanding dues from appellant. Appellant sent legal notice terminating the rights under the contract and seeking refund of the advances. A criminal complaint was also filed before the Chief Judicial Magistrate alleging that over false invoicing and moratorium. In fact, so in this case, the Guwahati High Court in fact quashed the criminal proceedings, holding dispute contractual and civil. Now the CD, in fact, the corporate debtor was admitted to CIRP in 21, and public announcement, all these claims were filed. Now, the appellant again filed their claim for about 18 and a half crore, and that claim was, now let us understand what kind of claim was submitted. The claim was not on invoices, claim was on kind of based on alleged breach, non-performance, which was not adjudicated by any court. So they in fact claimed that this amount is due to us because of the breach of contract or non-performance of the contract, but no adjudication has been done by any court so far. The RP rejected this claim. RP said that RP has no adjudicatory powers to admit damages claim without judicial order. So then the appellant allegedly owed the CD. In fact, there was a reverse, like instead of claiming, in fact, they're supposed to owe this. So the claim, in fact, was filed after an afterthought, the expiry. It was also filed 548 days delay. Now the COC, in fact, approved a resolution plan, and that resolution plan, of course, was approved after the claim was rejected. So the claim was filed while the CIP was going on, but the COC has not approved a resolution plan. So this is a different case. But the basic ratio, the basic principle, what is applicable here is the question of flaw before the appellate tribunal was whether the RP committed any irregularity in rejecting the claim. 1, because it is belated. 2, because it was damages based on non-performance, based on breach of contract, but there was no adjudication done by any court. So it was beyond RP's jurisdiction. Now the observation and decision of the appellate tribunal was First, the NCLAT Appellate Tribunal referred to Section 18, subsection 1, clause B, saying IRP to receive and collate all claims pursuant to public announcement. Regulation 10, RP may call for evidence clarification to substantiate claims. Regulation 12, claim with proof to be filed by last date in public announcement if missed may be filed up to RFRP issuance or 90 days from insolvency commencement date. Of course, that amendment came later, but this particular case is before the amendment. Then Regulation 13, Sub-Regulation 1 says the RP to verify claims within 7 days from the last date of receipt. Appellate Tribunal stated that the RP must act fairly and objectively as a facilitator and abide by statutory provisions while collating, verifying, and admitting claims. Again, there was an allegation on the RP that RP has been given 7 days for claim verification, but RP has done in 3 days. But then on this particular allegation, the appellate tribunal says, the allegation was that this rejection was mechanical within 3 days, and the tribunal held that IBC is time bound. Since the outer limit to decide is 7 days, RP cannot be blamed for deciding within 3 days, especially when resolution plan was at advanced stage of COC approval. Appellate authority looked at Form F and the various heads like inflated invoices, extra bills, and annual maintenance charges not performed, expenditures, loss of GST, ITC. So all this was totaling up to say 18.5 crore. The appellate tribunal held that these are damages, claims arising out of alleged non-performance, breach of contract, and could not be adjudicated by the RP within the RP's limited jurisdiction. If not, RP is not expected to verify claims without supporting proof, and damages claims need a competent court's consideration to crystallize. Unadjudicated damages claims are not crystallized claims, so RP's non-admittance was not unwarranted. It was held that the RP has a right to call for documents. Documents means wherever some kind of verification is possible. But in this case, even the additional document, there was no possibility of such claims. There was no possibility of such adjudication and the quantification of damages. So therefore, the basically the delay in filing also was huge. That was also, and also like the kind of criminal case before chief judicial magistrate. Now all this, and finally the appellate tribunal held that no surprise claim principle. The appellate tribunal stated the settled principle from Supreme Court decisions: no surprise claim should be thrown on the resolution applicant. Liabilities should be in the information memorandum, so a resolution applicant can factor them into plans. 45 days of delay and contingent damages nature, RP's reasoned rejection was upheld. That's very important. When this RP rejected, it was reasoned rejection. It was not mechanical. This allegation was incorrect. Accepting such late claims will disrupt time-bound CIRP and defeat IBC objectives. Timely submission of the claims. RP cannot accept belated claims. RP cannot adjudicate. RP has to get a reasoned rejection order. Final decision, NCLT found no infirmity in NCLT's order or RP's approach. RP, in fact, was appreciated that everything that he did was within law.
Next judgment is Raj Krishna Construction Company Private Limited versus Novera Solutions Private Limited. Raj KCC Private Limited was an OC in this matter, and they had filed this NCLAT application because NCLT had dismissed their Section 9 application as an OC. The grounds of dismissal here were discussed by NCLAT. All the facts were also discussed in the judgment. We will not go into those details, but in toto, what happened was that Raj KCC stepped into the shoes of another entity through an agreement. That entity already had a contract with Novera, which was the CD or corporate debtor in this case. And there were communications, or there was an agreement. That agreement with respect to construction of a particular project was then cancelled, and Raj KCC, through the earlier entity, had filed a claim and said that this is the amount that is owed to us because of the illegal cancellation of that contract. There was an arbitration proceeding that was initiated by Novera Solution back in 2023, before filing of the NCLT or the NCLAT application, which was again responded to by Raj KCC. So when this matter came up, or this disclosure came before NCLT or NCLAT, that an arbitration procedure or process was already initiated by Novera with respect to this claim of Raj KCC, they held that there is a pre-existing dispute which seems to be which was there before the notice, which is there before the reply to Section 8 notice. And based on that, NCLAT, NCLT first said that no, the matter is dismissed. NCLAT also agreed with the judgment of NCLT, saying that the OC's application in this case cannot be sanctioned. Rather, it was decreed, it was said that the NCLAT observed that the court does not need to decide if the debtor will win the arbitration. It only needs to ensure the dispute is a plausible contention and not spurious, hypothetical, or illusionary. So that is what the court then finally decided, that they held that it is a plausible contention because the arbitration is still in place. There is no finality of what amount is due. So they will not go into the decision with respect to whether it is they will win the arbitration or not win the arbitration.
Next judgment that I am deliberating is a judgment from partner Anand Sonbhadra, and it was a unique case. The day we won from adjudicating authority, I said that this will be reversed by the appellate tribunal, and that's what happened. Because had it not happened, then probably the lot of hue and cry in Bombay or Kolkata, where there are old buildings and there are tenants sitting there, and in case this IBC can evict all those tenants, I feel then all these buildings will actually turn into multi-story buildings, because some insolvency actually have evicted all those tenants who are there for. Now this case is Sumati Suresh Hegde and others versus Anand Sonbhadra, the resolution professional, and this particular judgment was dated 9th of January 2025. It was a jurisdictional conflict between insolvency law and the rent control protections given to tenants. Now, the facts of this case is that the case involves a dispute over possession of the property in Mumbai. Like the RP wanted to take a possession of the property which was in the possession of a tenant. And the insolvency legal here, see, when this the original tenant in fact had already died, and the legal heirs of that tenant, they were in fact enjoying the tenancy rights, and which was inherited by them from their ancestors. The property is in Mumbai and the appellant are legal heirs. And then in 2009, in fact, a court decree officially declared Mr. Hegde as a monthly tenant of the premises. Now, this monthly tenant concept is a great concept, that you continue paying your monthly rent and you are almost owner of the property. That is what is happening in most of the old buildings at Mumbai, or even in Delhi, like Old Delhi, or in Kolkata, old buildings. There are very kind of good properties, huge properties which are occupied by all these monthly tenancies. These monthly tenancy means that it doesn't expire, it doesn't actually gets over. It is like different from lease, it is different from rent agreement, it is different from lease agreement, because this is a monthly tenancy, which is very risky. And most of the landlords are saying that we should not end up in any case as monthly tenancy. Now, with this decree, which has declared this as a monthly tenancy, the court specifically restrained the owners from dispossessing or obstructing his possession without following due process of law. The corporate debtor in this case is Champa Lalji Finance Private Limited. They purchased the property from the original landlords, and while the tenants were already in possession. And the corporate debtor, in fact, filed an eviction suit against the tenant, citing bona fide requirement to demolish the existing structure and construct a new building, like everyone would like to do. As I said, that there are many old buildings where many old tenants are occupying, and in case everyone would like to construct a new building. And in this suit, the corporate debtor admitted that the premises had been let out to the defendant as a tenant. Then CIRP initiated in 2023. After the RP visited the property and found the appellants in occupation, RP filed an application before NCLT seeking to evict the appellants and take custody of the property. It was noted that during the proceeding that Mr. Hegde had passed away. So the NCLT Mumbai allowed the RP's application, ruling that the RP was in power to take custody of all assets of the CD. The tribunal held that Section 238 of the IBC, which gives code overriding effect, prevailed over Maharashtra Rent Control Act 1999, which protected the appellant's tenancy. Now, then, of course, appeal. Now, while the appeal was pending, the corporate debtor's original 2011 eviction suit was also dismissed for non-prosecution. In late 2025, the RP must not have prosecuted that. Now, the question of law, a very important question of law, whether the NCLT has jurisdiction to order the eviction of a tenant, whether the residuary jurisdiction of NCLT under Section 60, subsection 5 can be used to adjudicate tenancy disputes, whether Section 238, the non-obstante clause giving IBC overriding effect, prevails over Maharashtra Rent Control Act 1999. The appellate tribunal observed and set aside this NCLT order, that they actually observed that the adjudicating authority, the tribunal, has committed a patent error by failing to distinguish between a lease and a tenancy. Now, yes, we have taken many orders. When we are appointed as RP, IRP, then we take the custody of the asset. And in case the lease is expired, then we have the right to take the custody, and then there are orders from adjudicating authority directing the tenant to evict. But in this case, it was not a lease. There was already 2009 order in from the court that this was a monthly tenancy that will never expire. So he has a right to stay there, occupy that premises. A lease is for a fixed period and can be terminated via notice under the Transfer of Property Act. Appellate tribunal held the principle that once a tenant, always a tenant, unless the status is changed by contract or law. And also in 2009 court decree, it was held that the appellant is a monthly tenant. And NCLT held that their rights are governed by Maharashtra Rent Control Act rather than IBC. Appellate tribunal emphasized that the NCLT is not the competent authority to pass an order for eviction of the tenancy, while the RP is tasked with the taking custody of the assets under Section 18 and 25. This does not grant NCLT power to summarily evict tenants. If the tenant needs to be evicted, the RP must move before the appropriate forum or court of law, in this case, small causes court under the Rent Control Act, instead of pursuing all this. So this was completely rejected. No, in fact, I have to just give you a summary. If a tenant is living rightfully, and that right may be because of the unexpired lease, because of the unexpired period of rent agreement, or because of the monthly tenancy. If the tenant is living there rightfully, the RP cannot get him or her evicted, or that organization evicted, because the NCLT has no jurisdiction to deal with this tenancy part of it.
Next we have again an NCLAT judgment from the principal bench, which is between the Directorate of Information versus Gaurav Misra, RP and others. This is a judgment decided on 9th of January 25. And what has happened here is that NCLAT had earlier, vide their order dated 13th August 24, passed certain instructions against the Enforcement Directorate with respect to removing the provisional attachment on certain assets. And that is where what has happened is that the Enforcement Directorate here filed this application seeking recall of that judgment, saying that that has not allowed them the natural rules of natural justice, and they were not party to that matter, and the order was passed by NCLAT without seeking their views. And NCLAT understood that recalling of judgments is possible, especially where rules of natural justice have not been followed, and they recalled their earlier NCLAT judgment to the extent that it covered the deattachment of the properties, and they continued their order, or said that the order with respect to approval of the resolution plan will continue, but those parts which had ordered the ED to deattach properties or provisional attachment, they were removed. So uh, any references to this NCLAT order in this matter can be avoided in future, because this judgment effectively has been recalled through this judgment.
No, so I recall we were very happy when this judgment in fact came, which is titled as Vantage, because this judgment was based on a Bombay High Court judgment in the case of Shiv Charan. In that particular judgment of Shiv Charan, it was held by Bombay High Court that if a resolution plan is approved and the resolution plan has actually been the resolution applicant is not at all related to the promoters or any person as mentioned in section 32 capital A of IBC, then all the assets of the corporate debtor which are attached by enforcement directorate has to be deattached. That was the judgment of Bombay High Court. And based on that judgment, this judgment was passed by Appellate Tribunal NCLAT in the case of Vantage, and that is Alchemist Reality, I believe. Now, this order was also in favor of that the resolution plan is approved and the resolution applicant is not related to promoters and also qualifies under section 32 capital A. So therefore, all the assets which are attached by enforcement directorate has to be released. Now, on the very next day, another person came and said that this Shiv Charan judgment has been stayed by Honorable Supreme Court. And NCLAT, the appellate tribunal, said that nobody informed us that. So therefore, they also kind of recalled this order, basically for two reasons. One, that the stay of the Shiv Charan judgment of Bombay High Court was not informed to them, and that actually came a day later or almost on the same day. And also, in this particular case, the enforcement directorate was not heard. So therefore, based on these two things, the order was recalled. So presently, this matter is of course pending before Honorable Supreme Court, whether 32A would be applicable in case the assets are sold during liquidation to a non-related party, or a resolution plan is approved where the successful resolution applicant is a non-related party. That kind of matters are still pending with Supreme Court. However, the Enforcement Directorate is presently compromising wherever they see that it is a loss to the banks. They are restituting the assets in favor of the RP or in favor of the liquidator. Now, the other judgment that I would like to, it's like again, this is also from a case which is handled by AAA, and the citation of the judgment is State Bank of India versus IDBI Bank Limited, and this judgment is again dated 28th of January 25. Now, in this case, the appeals were filed by State Bank of India and IFCI against IDBI Bank Limited and the liquidator. They challenged the NCLT order dated 20th of December 23. The corporate debtor in this case was SD Aluminium Limited, and this case was in liquidation, and this was sold as the sale of the corporate debtor as a going concern in liquidation process, and the liquidator and the RP in this case is Deepika Prasad Bugra and partner of AAA Insolvency. So in this case, since the company, the case was in liquidation, and the liquidator distributed the proceeds from the sale of assets and considered and also based on the priority of charges and the value of security interest of each secured creditor. That was the basis for the distribution. And see, this some of the secured creditors, in fact, reached out to NCLT, and NCLT said, and it's again a case which is Technology Development Board versus Anil Goel, that is me, where the Ahmedabad NCLT decided that yes, this is the way the liquidator should distribute because of the earlier old judgment, Sidco Leather versus ICICI Bank, and also the report of the Insolvency Law Committee, which is released by IBBI and Ministry of Corporate Affairs. So the RP or the liquidator has done rightly, and therefore the Ahmedabad NCLT said that this liquidator, which is Anil Goel, and that was a case of Gujarat Oleo Chem Limited, so he has done rightly. But you see, the Technology Development Board, in fact, filed an appeal before the Appellate Tribunal, and Appellate Tribunal said that Section 53 doesn't talk about value of security or priority of charges. Rather, Section 53, subsection 2 very clearly says that if there is any agreement between the creditors of the same priority, and that will have to be ignored by the liquidator. So based on that, it was held that all the creditors will be distributed pro rata based on their total claim, of secured claim, not unsecured, total secured claim. So that judgment of Appellate Tribunal was in fact stayed by Honorable Supreme Court, and that was the judgment which was stayed. And in that case, it was basically an application filed by Kotak Mahindra Bank. Now, the various observations which was in fact made by, because see, once the Appellate Tribunal has already passed an order in the case of Technology Development Board versus Anil Goel, which is stayed by Honorable Supreme Court. Now, the Appellate Tribunal does not have any other option till the time the Supreme Court decides that particular matter. The Appellate Tribunal will continuously pass all such similar orders, and the Supreme Court will continuously stay all that till the time this is decided by the Supreme Court. And probably this will be decided after the Amendment Bill becomes Act. Amendment Bill 2025 becomes an Act. Now, in this case, Appellate Tribunal held that the statutory scheme under Section 53 of the IBC, Tribunal examined Section 53, subsection 1, clause B, subclause 2, and emphasized the words between and among. Between places workman's due and secured creditor who relinquish security at the same level in the waterfall. Among requires equality within the class of secured creditors, meaning inter-se distribution must be equitable. Section 53 does not recognize priority based on the nature or value of charge once secured creditors have relinquished their security. The NCLAT says that the binding Supreme Court precedents. The NCLAT relied on the law laid down by the Supreme Court of India in Resurgence ARC Private Limited versus Amit Metallics Limited, wherein it was held that secured creditors who relinquish their security under Section 53 form one class, and distribution under Section 53 must be made pro rata on the basis of admitted claims and not on the basis of the value of or priority of the charges. Now, this Amit Metallics was in fact a case which was only on the dissenting creditors' rights. It was not on the overall distribution. But for the purpose of exact amount which is due to dissenting creditors, for the purpose of arriving at the liquidation value due to the dissenting creditors, these sentences were used by the Honorable Supreme Court. The Supreme Court also in the case of DBS Bank Limited versus Ruchi Soya Industries Limited has disposed of a case but noted the issue of inter se priority among secured creditor and left the question open. But there is a difference. Ruchi Soya was a case of resolution plan. That was not a case of liquidation. And it is well settled that in a resolution plan, the distribution will be decided by the committee of creditors and their commercial wisdom. So therefore, this Ruchi Soya Industries Limited case is not at all applicable on this part, how the liquidator will distribute proceeds under section 53. Now, the issue of inter se priority of secured creditor is presently pending before Honorable Supreme Court, and that case is Kotak Mahindra Bank versus Technology Development Board. The name Kotak Mahindra Bank starts only because the Kotak Mahindra Bank was the first to file an appeal, but this case is basically from NCLT. This case is Technology Development Board versus Anil Goel. Now, see, until the Supreme Court takes a contrary view, this is what has held by the appellate authority. So therefore, all this, and the appellate authority, in fact, appellate tribunal also says that the Technology Development Board versus Anil Goel, that is the liquidator in the case of Gujarat Oleochem Limited, would not be applicable. ICICI Bank versus Sidco Leather, that's like the old cases, that's also the Insolvency Law Committee report is also not applicable. Undertaking from the creditors is also not relevant. However, the final decision was that it has to be redistributed considering everyone pro rata. But this case is also stayed by the Honorable Supreme Court after that. So presently, all these kind of cases are pending before Honorable Supreme Court.
Next, we have State Bank of India versus Santoshi High Volt Electricals Private Limited, a matter which was decided on 17th of March 2025. The main issue in this matter is that the NCLT, the facts are that the COC approved a resolution plan, and subsequently the resolution professional filed the resolution plan for approval before the NCLT, and the approval of the resolution plan by NCLT was pending. While it was pending, what happened was that bank guarantees amounting to some 15.84 crores were basically encashed by a third party, which is called EESL. And what happened based on this was that the total CRP cost increased to approximately 23 crores, and the CRP cost which was provided for in the resolution plan, which was approved by the COC, was only 2 crores. So what was effectively happening was that the excess CRP cost was becoming the burden on the secured financial creditors based on the plan provisions. So what happened here is that the application, or this was discussed in the COC meeting, that this plan should be recalled because it is no longer feasible, sustainable, and post that so the question of law here was whether the COC can request to remit back the resolution plan pending before the NCLT for approval. So it was decided finally, NCLAT dismissed and upheld the NCLT decision. It says that drawing on the Supreme Court precedents in Eviction, Singapore, the NCLAT observed that a resolution plan approved by COC and submitted to the NCLT is binding inter se between the COC and the SRA, and the tribunal noted that such a plan is not a typical contract and has binding effects. So it said that while it is pending, it cannot be remitted back to the COC for another decision as per law, and therefore this appeal was dismissed. This appeal filed by State Bank of India, pleading that NCLAT may allow the recall or allow the withdrawal of this plan for approval, was dismissed by NCLAT. So the plan approval, I think all COC members need to be careful about future proofing that plan. So even in case that is pending before NCLT or maybe approved by NCLT at a later date, so all these contingencies where a bank guarantee has been encashed and effectively the CRP cost has gone up, these contingencies must be in the minds of COC members when they're approving the resolution plan. There is no going back after they have approved it.
So the other concept is actually, it is something which is being misused presently is section 10 capital A of the IBC. This was inserted to give some protection to those defaulters who actually defaulted during the COVID period. That is starting from 25th of March 20 to 24th of March 21. So that was the period of 1 year which was excluded. So any default which actually has occurred during this 1 year period, the insolvency cannot start. This is also being misused by many. So this is a unique case which is where the appellate tribunal actually have checked this kind of misuse. Now I will come to, this is the case is Vinod Kumar versus Omkara Asset Reconstruction Private Limited and others. The date of judgment is 4th April 2025. In this case, the loan was sanctioned by IndusInd Bank to the extent of 300 crores and for setting up an IT project in Gurgaon. The loan was to be repaid in one shot and the bullet payment of 300 and after the end of 48 months, the interest was payable at 18%, 11%, default interest was 18%. The unpaid interest was to be capitalized and added to the principal amount. So the 48 tenure for the repayment was originally scheduled to end on 11th of August 2020. So 48-month tenure. It was a bullet repayment that ended on 11th of August 2020, that is within that 1 year period. However, during the COVID-19 pandemic, the RBI regulatory packages, this CD was granted to 3 months extensions moratorium, and this shifted the final repayment date for the principal amount, and that is the final date after two extensions was also 11th of February 21. So within this 1 year, before 24th of March 21. So therefore the CD failed to make the bullet repayment on February 11. Notably, this date is falling within the suspension period. So there was a prohibition that the insolvency cannot be filed. However, the financial creditor issued demand notice in June 2022 and SARFAESI notice also was issued in September 2021. IndusInd Bank assigned the loan to Omkara and Section 7 application was in fact filed by Omkara claiming 282 crores principal amount and also interest of about 9 crore. That interest, in fact, that interest was claimed even for a period which is beyond that exempted period. So the interest was also claimed from 26th March 2021 to May 31st 2021 because this particular the notice was issued on 1st of June. So for the month of April and May there was an interest default of about 9 crore. Now NCLT admitted and ruled that while the principal default occurred during 10A, the interest default occurring after March 25 exceeded 1 crore. So the interest default was continuing. Principal default was protected, but the interest default for a period after 25th of March 21 is again continuing. So therefore, the management, the CIRP started and the question of law which was framed before the appellate tribunal was whether CIRP can be initiated based on a default of interest component occurring after Section 10A suspension period, even if the default on the principal loan amount occurred within the protected period. So therefore, the observation of NCLT appellate tribunal, while Section 10A of the IBC prohibits filing for default occurring within the suspension period, it does not grant permanent immunity to debtors. It does not grant permanent immunity to debtors. The appellate tribunal observed that the statutory bar under Section 10A is intended to provide temporary relief to corporate debtors during the pandemic, but it does not wipe out the underlying liability or debt. Appellate tribunal held that if an outstanding amount continues after 10A period ends, the interest liability on that does not cease. Even if the principal repayment date, one short bullet repayment, fell within 10A period, the interest accruing on that unpaid period after March 25 constitute a fresh default. The tribunal noted that interest default occurring after 10A period are independent and can be served from the principal default since interest amount is more than 1 crore. So therefore, the commencement of CIRP was upheld by appellate tribunal.
We next have Deepak Mahadev Shirke versus Unity Small Finance Bank Limited. This is a judgment which was decided on 16th of April 25 by again the principal bench. In this judgment, the facts are that Deepak Mahadev Shirke, he is the suspended director of Excel Arcade Limited, which was the corporate debtor, and he challenged the NCLT order dated 27th of February 2025 admitting section 7 application with respect to the corporate debtor. And the facts are that the corporate debtor availed some credit facilities originally from PMC Bank, and later these were transferred to Unity Small Finance Bank. And the arbitration proceedings had initiated and then they got culminated. So what NCLAT has dismissed this, NCLAT accepted the appeal and dismissed or rather asked the NCLT to rehear the matter on the ground that although the NCLT had written the date of default as the original date of default, they took note of the arbitration matter and extended the limitation. So the question of law which came before the appellate authority was that could it extend the limitation by treating the arbitral award as giving a fresh cause of action and a fresh limitation period without the financial creditor formally amending section 7 application to change the pleaded date of default. So because the application was filed where the date of default was the original date of default, it was not relevant or based on the arbitration award, whereas the arbitration award was being used to extend the limitation period. So because of this technical issue, NCLAT sent back this matter to NCLT and asked the NCLT to decide it afresh. And in case, of course, an amendment can happen in this application, I believe that after the arbitration award was received by Unity Small Saving Bank, they can again say that this order has not been taken care of and the default is still continuing. So based on that, they can maybe again have a section 7 application in place. But yes, this was rejected because of the limitation period being used on a default date that was different as compared to the matter itself.
So I think what Ankit is saying, one part is very important, that the date of default, whatever is mentioned in the application, that cannot be changed just by argument or just by, if there is a change in the date of default, it is required that a fresh application or it should be actually amended in a process. So this is what exactly was held in this case by the appellate tribunal. It was remanded back to NCLT with the direction and with the liberty which was granted to the applicant that you can file a fresh application with a correct date of default. This is all for us. I am Anil Goel, insolvency professional. Ankit Goel, insolvency professional. We spend most of our time in insolvency practice. If you have any question, please do write to us on the email which is provided in the description below this video. Also, please let us know in case you want any specific video on a subject, may it be insolvency, rule, regulations, law or SARFAESI law. This is what we spend our time and this is what we like to do. And again, I will say this is our way of learning. Thank you.